Settlement agreements. What are they? Settlement agreements are designed to end an employment contract under mutually agreeable terms. The key points of the agreement are as follows. They must be in writing. They mostly include some sort of payment or possibly a reference. They must be legally binding. They must be voluntary. They can be offered at any time during employment. Why are they used? They are usually offered when an employment relationship is broken down between the employer and the employee. How can an agreement be reached? In order for an agreement to be reached, several things must happen. Number 1. As stated before, they must be in writing. Number 2. The agreement must relate to the dispute or the reason for proceeding with the agreement. Number 3. The employee must be allowed to get advice on the terms and the effect of the agreement from a legal representative. This is usually paid for by the employer. Number 4. The advisor must be named in the agreement and it must be signed by them in order for the contract to be legally binding. Why do you need a legal advisor? Legal advice is required to ensure that the employee is protected and that they are receiving the right amount of compensation. What does the agreement contain? The agreement usually has several standard sections, the first one relating to outstanding salary and holiday pay. Secondly, they may be offered an ex gratia payment to compensate for loss of employment. This is tax-free up to £30,000. The agreement will waive all claims the employee can make against the employer once the settlement agreement is signed. The agreement may also contain a clause which prevents the employee from disclosing the contents of the agreement to third parties. What if an agreement can't be reached? If an agreement can't be reached, the employer may use other methods to resolve the dispute. Firstly, they may go through a performance management review. Secondly, they may put the employee through a disciplinary. Thirdly, they may go through grievance proceedings. Fourthly, they may attempt mediation between the employee and the employer to resolve the dispute. However, if these routes are pursued and the employer does not carry out procedures correctly, it may be possible for the employee to bring an unfair dismissal claim against them. To find out more information, please visit our website tribunalclaim.com. No win, no fee employment solicitors.